Bismillahir Rahmanir Rahim. Then Al-Hafiz said, Babul Qasama, the chapter of Al-Qasama. And in the language, Al-Qasama is when you take many oaths, or when you exaggerate in taking oaths. In the Sharia technical terminology, Al-Qasama is when oaths are repeated by somebody who is claiming that another person has killed a relative of his. So this would be a situation where a person has been murdered and the killer is not known. However, we do have strong indications which tell us that a particular person is the murderer. Perhaps it could be that there is a gang warfare between the two, or there is a known enmity between the two, or one has made his intentions clear that he intends to kill the other person. Most often, there would be tribal conflicts between two people. And in the days of Jahiliyyah, most commonly this would be the strong indicator which suggests to us that a particular person is the murderer of the victim. But as Shaykh al-Islam Ibn Taymiyyah says, it does not have to be tribal conflicts. Rather, it is just any strong indication which makes it predominant in our thoughts that such and such a person is the murderer of the victim. Let us take these two narrations of this chapter. 1034 وعن رجل من الأنصار رضي الله عنه أن رسول الله صلى الله عليه وسلم أقر القسامة على ما كانت عليه في الجاهلية وقضى بها رسول الله صلى الله عليه وسلم بين ناس من الأنصار في قتيل ادعوه على اليهود. رواه Muslim. From a man from the Ansar, we don't know his name, he says that in the days of Jahiliyyah, this system of Qasama was in place, and the Prophet acknowledged this system, and he used this system of Al-Qasama to judge in a situation about a man from the Ansar who was allegedly killed by the Yahud. Muslim reported it. And Hadith 1035 from Sahal ibn Abi Hathma, it's a longer narration, so we'll go into the translation in order to save time. He narrates from some senior men of his people that they told him that Abdullah ibn Sahal and Muhayyisa ibn Mas'ud, both of them went out to Khaybar due to some difficulty which had afflicted them. And then what happened is that Muhayyisa returned and he informed the people that Abdullah ibn Sahal had been killed and his body had been thrown in a well. So he came to the Yahud and he said, Wallahi, you are the ones who have killed him. And the Yahud refused to acknowledge this. They said, Wallahi, we did not kill him. So Muhayyisa and his brother Huwayyisa, and also Abdurrahman ibn Sahal, the brother of Abdullah ibn Sahal, these three men came to the Prophet and informed the Prophet what happened. They all wanted to speak. So the Prophet said, Kabbir, Kabbir, meaning to say, let the eldest amongst you, the one who is the Kabir, let him speak. So the eldest was Huwayyisa, so he spoke, and then after that Muhayyisa spoke, and so they informed the Prophet what happened, and the Prophet said that either the Yahud must pay the blood money or they must take notice of war. So he wrote to the Yahud informing them of this decision of the Prophet, and the Yahud wrote back, they said, Wallahi, we did not kill him. And so the Prophet told Huwayyisa and Muhayyisa and Abdurrahman ibn Sahal, will you take some oaths to back up your claim that the Yahud killed Abdullah ibn Sahal? So if you do that, you will be entitled to take revenge. They said no. So the Prophet said, if you won't take the oath, then the Yahud will be entitled to take the oath and free themselves of any responsibility. And so the three replied, but these Yahud are not Muslimin, meaning to say that they will take an oath and who cares what they say. It's not like they have the fear of Allah. And so in response to that, the Prophet paid the blood money for Abdullah ibn Sahal from his own self, meaning from the treasury, and he sent them 100 camels, and Sahal says, a red camel from amongst them kicked me. This narration is muttafaqun alayh. So here in this narration we have the situation of al-Qasama. A person is murdered, we don't know who the murderer is, but we do have indications which strongly suggest to us that the murderer is a particular person. In a case like this, the people who are claiming that such and such a person has murdered their relative, they take the oath. And we know from the narrations that they take 50 oaths amongst themselves. And if they refuse to do this, then the defendant can take 50 oaths and he will be free from any blame at all. Now, why is this a weird situation? It appears to be a weird situation because of three factors. Number one, the person who is making a claim, he is to take the oaths. Whereas we know the general rule is, the Prophet said, البينة على المدعي واليمين على من أنكر. The burden of proof is upon the one who makes the claim, and the one who rejects the claim, then he simply has to take an oath. But here the claimant is making the oath. In fact, he's taking 50 oaths that such and such a person killed my relative. So this appears to go against what we know to be the case normally. The second point is that you are taking 50 oaths, and we have not known any situation in the Sharia in which you take 50 oaths. Normally just one oath by Allah is sufficient. And thirdly, the person who is taking the oath, he is the one who is making the claim in this case, he's taking an oath about a situation which he has not seen or observed. And normally in a court case, when you take an oath, then you have to take an oath if you have actually seen the situation. For example, if you take an oath that you caught somebody committing zina, then you have to have seen them in the act, not just suspect that they were committing zina. So it needs to be as clearly as you see the sun. But here in this case, the claimant clearly has not seen the murder take place. And so because of these crucial factors, which appear to go against the normal rules of the Sharia, some scholars have rejected this idea of al-qasama. However, we can argue against these three factors if somebody argues that they appear to go against the Sharia. So, factor number one, that the claimant is making the oath, well, we say that certainly in most cases the one who makes the claim, the burden of proof is upon him, and the one who takes the oath is the defendant. However, we say, more accurately speaking, the oath is taken by the one who has a stronger case for him. Because you see, the reason why the defendant would take the oath is because the claimant has failed to provide evidence. And because he has failed to provide evidence, this makes the side of the defendant stronger. And so because his side is stronger, then the oath is upon him. But in the case of al-qasama, the stronger side is with the claimant. And this is due to the qarina, or the indication that we have on our hands. So in this case, the claimant is justified in taking the oaths. Number two, that these oaths are repeated 50 times, and this is something strange. Well, we say the reason why we can justify the oaths being taken 50 times is because this is a matter of blood on our hands. It's a matter of life and death. If these people, the claimants, take 50 oaths, they will have the right to kill the alleged killer. And because of this, you must repeat the oaths and take them a total of 50 times, because as you are taking these oaths in the name of Allah, if you feel that you've got the wrong person, then during these 50 oaths, if you have any fear of Allah Jalla wa Ala, then you will change your mind. So these 50 oaths are really there to make you think, rethink and rethink and rethink and so on. Because the point is that if it was just one oath, then somebody could take this one oath and then immediately afterwards regret his decision. So the 50 oaths are there to prevent people regretting their decision. So if a person does manage to take these 50 oaths, then it shows that he is extremely confident that he has caught the killer. And as for the third factor, that you take an oath about what you haven't seen, well, we say that you are, in the Sharia, allowed to take an oath in accordance with not what you have seen, but rather in accordance with what is predominant in your thoughts. And we have evidence for this, the famous hadith about the man who had intercourse with his wife during Ramadan. He took an oath by Allah that there is nobody in Al-Madinah who is poorer than he is. Clearly this man has not seen every single family in Al-Madinah, but he's taking this oath in accordance with what is predominant in his thoughts. And as we find, the Prophet acknowledged his oath. So we find then that all three of these objections can be reasonably explained. And so this al-qasama is in accordance with the fundamental principles of the Sharia. And we find it was in effect even in the days of al-Jahiliyyah, which means that when it comes to things which are decent and proper, then the Sharia does not object to that. It only objects to those things and the customs of the people which are in contradiction with the wisdom of Allah Jalla wa Ala. We take from this narration that the Yahud are a people who cannot be trusted as a whole. Sure, amongst them you could find people who are trustworthy, but this is not an argument because there's a difference between an individual person and a community as a whole. So when it comes to the community as a whole, then they are not people that can be trusted. Because in this situation of the narration, it is most likely that one of the Yahud did in fact kill Abdullah ibn Sahal. Because we know Khaybar is a place where the Yahud were. They used to work there growing the fruit trees, and it is more than likely that the killer was from the Yahud. And the Yahud are known for their treachery and breaking of the oaths. The tribes of Al-Madinah, who were Yahudi, all of them broke the covenant with the Prophet ﷺ. Whether it is Banu Nadir, Banu Qaynuqa, or Banu Qurayza, all of them proved to be treacherous to the covenant with the Prophet ﷺ. This strong indication, which makes it predominant in our thoughts that such and such a person is the killer, this in Arabic is called the lawth. So if there is no lawth, then we don't have a qasama. So in the absence of a lawth, the only way in which the murderer can be identified would be by way of evidence or by way of a confession. So in the case where we do not have a lawth, if somebody claims that such and such a person intentionally killed his relative, then we do not pay this claim any attention, unless he brings some form of valid evidence. However, what about a case where the claimant does not have any evidence, and neither do we have a situation of a lawth, but he claims that such and such a person has killed his relative unintentionally, so out of khata? In a case like this, the famous opinion from the Hanbali madhab is that we would ask the defendant to take an oath that he did not in fact accidentally kill the victim. If he does that, the matter is decided. If he does not do that, however, they say we will judge against him and he will have to pay the blood money of accidental murder. When the person asked to take an oath does not take an oath, this is called an-nukul, and these scholars say that we will judge against him because of this nukul. Because the fact that he does not take an oath is an indication that he is the liar, or that he is in fact guilty of this accidental murder. Therefore we would obligate him to pay the blood money. However, they say that if the claimant was making a claim of intentional murder, and there is no evidence, and there is no lawth, then in a case like this, we would not ask the defendant to take an oath. So notice the difference here. With the claim of unintentional murder, which is the khata, they say we ask the defendant to take an oath. If he does not, we judge against him. But in the case of intentional murder claim, they say we do not ask the defendant to take an oath to clear his name. So why is there a difference? They say the difference is because when it comes to the claim of accidental murder, then what the claimant wants is the money. Wealth is involved. But when it comes to intentional murder, then what the claimant wants is the life of the alleged murderer. He wants retaliation or qisas. And because this is far more serious, we do not ask the defendant to take an oath, such that if he was not to take an oath, we would judge against him. So we cannot take somebody's life simply because he refuses to take an oath. No, rather we need something stronger than that. But as for wealth, then we can judge against him if he refuses to take the oath. Some other scholars have said, no, even in a case of intentional murder claim, we would ask the defendant to take an oath. So if he takes the oath and he says that he is not guilty, then we judge by that he is not guilty. However, if he refuses to take the oath, then we do judge against him, just like in the case of the accidental murder claim. However, the claimant is not entitled to the qisas, rather, he is only entitled at best to the blood money of intentional murder. So you can see that this opinion is stricter and harsher on the defendant. And the reason is because they say, similar to the previous opinion, that the qisas cannot be established simply because the person refuses to take an oath. But when it comes to money matters, then this can be adjudged against the defendant because he refuses to take the oath, which is an-nukul. We take from this hadith that the Yahud do have veneration of Allah Jalla wa Ala. This is why they refuse to take the oath. However, their veneration will not avail them in aught because they completely reject the prophets of Allah Jalla wa Ala. They reject Isa alayhi salam and they reject the last prophet as well. And similarly, they did not show any respect to Musa alayhi salam. In this situation, in the hadith, we find the Prophet is giving a fatwa regarding somebody who is not present, because Muhayyisa and Huwayyisa and Abdurrahman ibn Sahal, they're the ones who came to the Prophet about this situation which they had. But the Prophet did not consult the Yahud. And so this is the Prophet giving a fatwa without the other side being present. Whereas in a case of al-qada, which is when you judge between people, then you need to listen to both sides of the story. And we found a similar situation with Hind, the wife of Abu Sufyan, when she came to the Prophet and claimed that Abu Sufyan is stingy, he does not spend on her nor her children. We take from the hadith that if the claimant takes the 50 oaths, then he has the right to kill the alleged killer. Some scholars say that if he takes the 50 oaths, then he does not have the right to kill the alleged killer, but he can take the blood money of intentional murder. But in the Arabic of the hadith, the Prophet says, فَتَسْتَحِقُّونَ دِمَاءَ صَاحِبِكُمْ, then you will be entitled to the blood of your companion. So this suggests to us that they are allowed to kill the alleged killer. Also, we can take from the hadith that if a kafir takes an oath, then in a court case we would accept this oath if you are judging between two people. We take from the hadith that if we are unable to establish the killer, then if an innocent person is killed, then his death must not go to waste. Rather, the treasury would be responsible for paying the blood money. We find at the end of the narration, Sahal says that one of the camels, the red one, kicked him. This does not bear any relationship to the issue at hand, but it goes to show us that Sahal is telling us that he recounts this incident clearly, such that he even has memory of the non-relevant information. So this goes to show that he recalls it clearly and he knows what he's talking about. And similar to this are those narrations which are musalsal. So every time a narrator narrates to his student, every man in the chain of narration, they would perform a similar action, or they will say it in a similar way. For example, the hadith where the Prophet says that not even his actions would be enough to enter him into Jannah, except if Allah has mercy on him. And the Prophet put his hand on his forehead when he said this. And so we find that in this chain of narration, every man who is narrating the hadith similarly put his hand on his forehead. This is musalsal, something which is connected or continuous. So these little details like this show that the narrator has full recollection of what he's talking about, such that he would even recall the non-relevant information. Question: can we have al-qasama when it comes to limbs? The answer is, if we can have it for life, then we can have it for limbs. So somebody claims that another person chopped off his arm, but he does not have any proof, but there is a lawth. So in a case like this, al-qasama can be made. And this is by way of analogy with the life, because if it can be made with the life, it can be made with the limb. Some scholars say because al-qasama is not in accordance with the general principles of the Sharia, it is very much an anomaly, then we are not allowed to make analogies from something which is an anomaly. However, we say al-qasama is not actually an anomaly. We dealt with this issue before. The objections which they come out with, which are 3 of them, are in fact not valid objections when we think about it. So al-qasama is in accordance with the Sharia, and if it is in accordance with the Sharia, then we can make an analogy. Majority of the scholars say that al-qasama cannot be made when it comes to matters of wealth, that al-qasama is only pertaining to life and limb. Rather, if somebody makes a claim with regards to the wealth, then in a case like this he has to provide evidence that somebody owes him money. And you could argue that if it is the case with the life and limb, then it should be even more so the case with wealth. But if we say that al-qasama can be made with the limbs, then do the oaths have to be repeated such that you say it a total of 50 times? The answer is yes, because when the claimant takes the oaths 50 times, then this is a strong indication that his side is stronger. Because remember, he does not have any proof. The fact that he takes it 50 times is a strong indication that he is sure in his mind that the guilty person is as charged. In the case of al-qasama, where the relatives will take the 50 oaths, if we cannot find any males, then do the female relatives have the right to take the oath? There is a difference of opinion on this issue, but what appears to be the more sensible thing to do would be that if there are no males, then the women would take the oath, so the right of the claimant does not go to waste. The majority of the scholars say that when it comes to al-qasama, then the relative who is going to take the oath, he needs to specify one particular individual whom he charges with murder. So he's not allowed to say that a group of people killed my relative, rather he needs to specify a particular personality. If he cannot do this, then there is no qasama. Okay, so what about this issue of taking the 50 oaths? The wording in one of the versions of this hadith is that the Prophet says, وَيَحْلِفُونَ خَمْسُونَ مِنْكُمْ, and 50 from you will take an oath. We said that the people to take the oath would be the men, not the women from the inheritors. But can one man take 50 oaths, or do you have to have 50 males taking one oath each? One opinion is that you can just have one man taking 50 oaths and this would suffice. And if you have many men who are inheriting, then they will divide the 50 oaths between themselves. So each man might have to take 10 oaths or 15 oaths, depending on how many they are. If there are 3 of them, for example, then 3 does not divide exactly into 50. Then even if they were to take 17 oaths each, now 17 times 3 is 51. So this makes 51 oaths in total, which goes above 50, but there's no problem with that. You can take 51 oaths, we don't have to be so accurate, because they've taken the 50 oaths which was required. Another opinion is that you need to have 50 men taking one oath each, because the Prophet says that 50 from amongst you will take the oath. So this indicates 50 people. And they say that this is more in accordance with what is apparent from the wordings of the hadith. And also, if there are 50 people, then there's more of a chance that they will not take this oath, because some of them could remind and give nasiha to the others. They could say, look, perhaps it's a better idea that we do not take this oath, because there's a chance that this killer may actually not be the killer. So let's think about this and be on the safe side and refrain from taking the oath. So this is a possible benefit, whereas if we leave the matter down to one person, then actually we're leaving it down to his whims and desires. And so he might readily take the 50 oaths, and we could end up killing the wrong person. So upon this second opinion, how would it work? Well, we would look at the immediate inheritors of the victim. They would take an oath each. And then after that, we look to the inheritors of the inheritors, and they would take an oath each. And then we keep on going further away from the victim until we make up the 50 men. And of course, these 50 men are not just any old 50 men, they are the male asaba, so we will not have any females in this. So with regards to the females, some ulama say that the females do not take the oath, and if there are only female inheritors, then qasama cannot run, and the blood money for the victim will be given by the Baytul Mal. And some other ulama say that if we don't have any males, then the females can take the oath. If it's the case that the inheritors do not take the 50 oaths, whichever opinion we follow, whether one person can take 50 oaths or whether we need 50 different men, in either case, if the 50 oaths are not taken, then the one who is accused of being the murderer, he can simply take the oath. But the question is, how many oaths do the defendants need to take? Well, they also take 50 oaths because of the wording in Sahih Muslim, فَتُبَرِّئُكُمْ يَهُودُ بِأَيْمَانِ خَمْسِينَ مِنْهُمْ. So 50 oaths from the Yahud would free you. So we say that the relatives of the defendants, 50 amongst them will take an oath each, and then they will be free of any charge against them. We can take from this hadith as well the virtue of being older, because the Prophet wanted the oldest amongst them to speak. And so this would apply in a situation like this as well, when we have a whole host of people all wanting to speak. Well, we give priority to the eldest. If they are equal in other affairs, like they are equal in their knowledge about the topic. And we can say the same thing when it comes to the imamah, who is going to lead. If they are equal in the other qualities, then the elder of them is going to lead the prayer. Similarly, when it comes to the walaya of the nikah, who will be the wali of the woman if they are all equal in status. So let's say they are all Muslims and they all know how to be the wali, then we would give precedence to the eldest of them. We need to make a note of a few things before the al-qasama can take place. Remember that the person being accused of the murder, needs to be a mukallaf, and it does not work if somebody is ghayr mukallaf. And also all the inheritors must agree that this suspected person has killed our relative and we want to take revenge. So if one of the inheritors does not agree, then we do not have al-qasama. And this is similar to taking the qisas. You'll remember we gave the conditions for the qisas to be taken, and we said that all the inheritors must agree, because there can be no qisas without the agreement of the inheritors, because you cannot kill the suspect for some of the inheritors and not kill him for other inheritors. He's either killed or he's not killed. We cannot have anything halfway. And also from the conditions, like we said before, the killer needs to be specified. It is possible to specify 2 killers, because they could say that both of these men, we suspect, gathered together and they cooperated or they conspired to kill our victim. This is possible. And also the people who are going to take the oath have to be mukallaf and they have to be dhakar, males. So it cannot be taken from somebody who is insane or somebody who is not mukallaf or somebody who is not a male. And some scholars say that if males are not found, then females can take the oath in a case like this. So there's a difference of opinion on that particular issue. Can the females take the oaths or not? Okay, let's take some review questions. So, question number 1. Explain what al-qasama is, linguistically and technically. Question number 2. Explain what we mean by an-nuqul in a court case, and whether we can use this nuqul to pronounce a judgment regarding wealth or blood. Question number 3. At the end of the narration, Sahal ibn Abi Hathma says that one of the camels of the blood money kicked me. This appears to be irrelevant to the topic of the hadith, but explain why it is still valuable information.